I've been speaking with a constitutional lawyer, GT Ogunye, and a lawyer and political affairs analyst, Libros Oshoma, who is joining us via Zoom tonight to discuss on the final verdict of the Supreme Court, which has affirmed President Bola Tinubu's election victory. Mr. Ogunye, let me come to you. One of the justices described Atiku's appeal as vexatious, and now his party has rejected this verdict by the Supreme Court. Why this vexation? I know you've said a bit about it, but then why this vexation?
You know, these are terms that are available to judges to use to describe the frivolity of a course of action. I mean to say that there's really no course of action here, that this is just nothing but legal sophistry or a hype, you know, that it has no substance, that is empty. So you hear such terms as frivolous, vexatious, and an abuse of court process and all. And lawyers also use this to urge the judex to dismiss the case of their opponents. And why they have said that, it's not far-fetched. Here was a politician who is court seasoned, litigation seasoned. He's been coming to court many times. And he has lawyers who are senior advocates of Nigeria, who are well known in the polity, who have also been coming to court many times. And yet, that kind of petition was presented. In the first instance, a petition that alleged irregularities in an election and claimed that the person who was declared the winner didn't garner the votes they are claiming he garnered. Usually, when you say the votes, you know, given were allotted and that your opponent didn't garner those votes, what you are supposed to do is that you then show the actual votes so that the court can compare and contrast and say these were the actual results. But none of these was done. So it's all sand and fury, as I said, signify nothing. And then in the polity, people were given the hope, you know, that something big was going to come out of the judiciary. And then, worst of all, the judiciary was now portrayed as an institution that was dispensing or was going to dispense injustice. And so there was mass bullying of the judiciary because the judiciary was set up that they weren't going to do justice. And yet, the matter was so frivolous. It was not the only frivolous one. The other person was saying his mandate had been stolen, that he won the election. I mean, people should take responsibility. It's not something you just say for saying sake. That you won the election. How did you win it? And then you demonstrate that. But you didn't do that. And that was why the lower tribunal awarded cost, huge. In the circumstances, you could say that they have deep pockets, but millions of naira is not chicken change in this economy. And so the court, you know, the Supreme Court had every reason to castigate the petition and declare it frivolous. More so when the issue that was brought to the Supreme Court by way of an application was the issue of a matter that didn't form part of the case of the person who was pushing it, which was the CSU shenanigans and all the things that came with that. And I think that the Supreme Court was right. All
right, so you raised another valid critical issue, which is bullying of the judiciary on social media and in broadcast stations. I mean, some analysts have called for punishment against those attacking the integrity of the judiciary. How do we go about this? Because this needs to be addressed.
You know, we're a democracy, and in this democracy, the right to freedom of expression, Section 39 of the Constitution, Article 19, is guaranteed. But you see, that freedom comes with responsibility. And that's why, even though it's the norm that when a matter of public interest, as indeed the election petition was, is being considered by the judiciary, Nigerians have a right to debate it, to discuss it, but not to predetermine the matter and level allegations against the judiciary, clobbering the judiciary, and all that. That's bully tactics, which is unacceptable. You know, you already knew that what you are presenting will not get you judgment because you know that it is hollow. All your supporters know that it is hollow. Or you are manipulating your supporters and telling them you have something very solid when you knew that it wasn't solid. And then the judiciary is then portrayed as a bad institution and all that. It then becomes the sacrificial lamb. That's not fair. You can discuss issues, you can discuss as we are doing now, but you know, I criticize the judiciary. I've gained, renown in doing that. You know, I've called for arrest of judges before, and I said that was the law at that time on the Supreme Court, then did something different in the case of Ganjiwa when judges were arrested in this country, that there is no immunity preventing judges from being arrested. I said it in this country, and I've said other things. But when it comes to an issue of determining a matter like this, parties and their counsel have a right under the law. There's a mechanism for writing to the authority and say, look, let this panel recuse themselves for 1, 2, 3 reasons. Recall that the last time, Alhaji Atiku Abubakar petitioned or wrote to the President of the Court of Appeal, who was then presiding over the election petition of 2019 between him and Buhari, and said that he didn't have confidence in the President of the Court of Appeal then. And there was a ruling on that point, and the President recused himself. Himself, though a lady, but the President recused himself. Never mind that the husband of that same President later went to the floor of the National Assembly now to then say that it was until the presiding president then said that he should off the mic, that he shouldn't go that route. But the president recused himself. The point being made is that if you believe you don't have confidence, you can raise it and the judiciary will treat it. But to sit back and then say that the entire judiciary is useless, they've been compromised, they've taken money, and I don't think that that's fair. More so when those judges cannot, give any reports, cannot grant press interviews or, address the media and say that, look, this is not right and all that. They only speak through their judgments. And so that's why on this occasion, both at the Court of Appeal and this one, they spoke about the social media and all that. And I think that they reacted to it in a measured manner very rightly. And I hope that our colleagues who do this, who then encourage people to do this, can take heed. If you are a senior advocate of Nigeria, for example, every lawyer is admitted to the bar as a solicitor and advocate of the Supreme Court of Nigeria. So you are a senior advocate, you are a senior advocate of the Supreme Court of Nigeria. If you destroy that Supreme Court by your impassioned speech, though unfounded, castigating everybody and all that. So that means you are just destroying yourself. Because there will be no judiciary left. There will be no Supreme Court left at the end of the day for you to be a senior advocate of. So it's unreasonable, if you ask me.
Mr. Libros, let me come to you. Now, when we talk about reforms needed to sanitize our electoral process, I mean, a large percentage of stakeholders will say amendment of our electoral law. For better perspective, what needs to be amended? Mr. Libros, are you there? All right. Mr. Libros.
Can you hear me now?
All right. Yes, I can. Please go ahead.
Can you hear me now? Okay then. Yeah, I said before I go into the areas of the question you asked me, please permit me to quickly also say something about the petitions that were filed for the benefit of our viewers. A situation where you come to the social media and you say you won an election, and then you get to court, you say, no, I didn't win. Declare the election inconclusive, or disqualify a candidate, and now let us redo the process. But in the court of public opinion, you are telling your supporter that you won. But in the court of law, you are praying for a separate thing. It becomes conflicting and confusing for those people, for those of us who are watching and monitoring proceedings from both ends. When you now try to tell those in the court of public opinion that no, these are not the prayers in court, in the court of law, then you are now seen as the devil with a green horn. That's one side. And then secondly, you start a petition with, oh yes, the petition, the election was inconclusive on the ground that our FCT requires a 25% vote. And you want the court to determine that it is so. And then the next day you say, no, now it is no longer about 25%, it's about qualification, it's about forgery, it's about conviction. And then the court overrules you on that. You go to, oh yes, we need to talk about, oh, there is a certification, there is no certification. I think when you keep shifting the goalposts in an election petition simply because you want to pander to the sentiment of the general public, I do not think that is pandering. I also think it is taking the public for granted, especially knowing fully well that the mass of the public are largely, uneducated in as far as electoral jurisprudence is concerned. So because what is technicality in the everyday civil matters will not be a technicality in electoral practice because the law is strict in as far as electoral practice is concerned. But that said, when the APC were in opposition, they clamor for the fact that there was recommendations of the waste panel report. The president should not be the appointer of the INEC chairman, that the resident electoral commissioners, because he also will participate in election that they are going to conduct. A situation where you appoint people who are going to, the umpires in a process, in a match that you are going to be part of, the tendency that the umpire will be biased is high. These were some of the recommendations of a waste panel that APC, whilst in opposition, beautifully clamored for. Also, that the presumption of regularity should not heavily be in favor of INEC. There should be a window where INEC would, the onus of proving that provisions of the law had been complied with should also rest on INEC, considering the fact also, the 21 days window and the fact that these materials also are with INEC and you need to apply for certification and the time for doing all of this, it's no longer there. And lastly also, the time, the 180 days for proving presidential election petition is not adequate. And I also think that election in most cases should be conducted when you have the umpire who should be unbiased and who should not be appointed by the participant, like was recommended, that there should be, something like electoral college that can nominate at least 3 persons, and then out of these 3 persons, 6 stakeholders, and then out of these 3 persons will be interviewed, and then they will be recommended to the president, who can eventually appoint one. And then on the issue of regularities. So when you put, when you put all of this in perspective in place, you will have an election that would be rancor-free to a very large extent. And this attitude of going to court and ventilate would no longer be there. And this attitude of saying, just swaying until all the electoral disputes are dealt with will no longer be there. So we need to, pursue a rancor-free election.
Mr. Libros, we're out of time. Sadly, we're out of time.
Okay, thank you.
Thank you so much. But gentlemen, I believe this is an ongoing conversation, especially for young people out there and generally for Nigerians and for politicians, like you've said, Mr. Judiciary. Lessons to be taken away from that judgment. Right, thank you so much for coming on Politics Tonight.